what do we want to think about today is what should we be transparent about now that would help improve confidence in the event that we're called to use our Title II authorities. And we've been thinking about this across, many dimensions. First, we look at who we need to be transparent for. And we have a large number of lists on this slide that you can see. We've done a lot of work with policymakers and regulators around the world, has been said, and a lot of engagement with certain parts of the firm. So the slides on the right, we've probably done more on, but what do we need to be thinking about for the stakeholders, the general public, customers, counterparties, other people like that? We think about what message do these stakeholders need to hear, and it might not all be the same. And then we think about when we need to be transparent. And I know that there's going to be a temptation for people to say, FDIC should just lay it all out there. Say what you're going to do every step along the way. And that pre-commitment will help improve confidence. But we also need to be mindful of the need for FDIC to have operational flexibility to adjust to the specific facts and circumstances on the ground. Next slide, please. So this slide is some topics that we're considering, the what of what we need to be more transparent about. And so what we would like to hear from you is which of these topics or others that might not be on here, thinking about contracting authority, which I took off the slide and now maybe I shouldn't have. What are the things that would be helpful to get out in the public domain to improve confidence now? So some of the things we've heard about obviously are, what are the key decisions that the FDIC has to make? When would you decide the framework? Is it going to be, is Title I bankruptcy going to work, or do we need to turn keys for Title II, which basically hinges on the need for liquidity through the OLF, I think. How do we decide the resolution strategy? Does the firm have enough capital to make an SPOE work, or do we need to be thinking about an MPOE? Do we need to be more transparent about how we coordinate cross-border, how it would differ if we're a home or a host? For example, we get questions about planning for the bridge as well. Who's going to run this bridge? What assets and liabilities will go into it? And how will the FDIC oversee what's happening at the bridge and maintain that for a public confidence perspective as well? We're thinking about creditors. How do you communicate with claimants, including about their claims determination? How will the losses be allocated on the Dodd-Frank hierarchy, which is different than under FDIC Act and under bankruptcy? And then how will the claimants be compensated? How does securities for claims process work? We mentioned that in the 2013 thing that Betsy mentioned earlier. We're also wondering if we need to be more transparent about some of the accountability mechanisms that we have as well for the general public audience. We are required to remove culpable management. How would we go about doing that? Do we need to re-emphasize that in the Dodd-Frank hierarchy that compensation claims are subordinated to general creditors and that prior compensation could even be clawed back if needed? And then finally, there's the funding mechanism. What part of that would be most helpful to boost confidence? I do think that the OLF and using it as the big gift, it's not a gift, but the big tool that we need in Title II to help provide confidence. But what do people need to know to really get that? How important is it to explain the rules and the mechanics for the OLF? How money will get from point A to point B? How would we use targeted guarantees to allay concerns about excess cash use? There's a lot of questions here. And so, there are a lot of things we've been thinking about, and what we want to hear from you today is what you think the priorities would be in order to go about setting expectations appropriately in public about how we would execute Title II. So that if and when we do have to have that announcement on Friday night, ideally Friday night, that people are in a position to receive it, understand it, and say, yeah, that works. And we can see how this will happen. Of course, there will be doubters, but there's a lot of things going on. So with that.
First of all, I'd like to praise the FDIC for its unrelenting pressures to have more disclosure under the actual public reports. I think they have been very helpful. Second, I guess I am a bit pessimistic about your ability to communicate with the people who really need to know in terms of a crisis. And this is partly from my experience of teaching this stuff. There was a lot of interest just after the crisis. It's dwindled over time. And so people are sort of less and less interested in getting into the nitty-gritty and some of the really interesting developments. So I would think your strategy ought to be to disclose as much as possible to people who professionally need to know about it, And that would certainly include the ratings agencies and the people within the banks who are responsible for these judgments. And simply have publicly available a place where people can go if they need to know more. Because we're dealing with a society where people are getting their information in tweets. There's just no patience, I think, for going through the elaborate and careful planning that has gone on. It should be there. It should be accessible when people need to know. But I don't think you have much hope of reaching a public that doesn't have a professional need to know.
I completely agree with that. I almost think you'd scare the public if you put this out. Like, why are they telling me this? Should I be concerned about my bank? Like, my insurance company doesn't tell me what they're doing with my assets. They just assume they're going to pay my claim, right? I think you've got to think of the unintended consequences of taking a public that has more full faith and confidence in the banking system than maybe people in this room do. That we want them to have full faith and confidence in the banking system. They know the FDIC insurance is there. They know it works. They put their money in. They're going to get their money out. So there's a select crowd of people that are in the institutional side. And if they want to understand this, they're going to find a way to understand this. There's a bunch of law firms represented in this room. There's a bunch of people who charge them by the hour a lot of money to explain this all to them. And it's fine. I don't have a problem with that. And they all have huge staffs. But I would be careful about the unintended consequences of starting to blast too much of this out in the general public.
So I'd like to take a slightly different view, and maybe a middle ground in the center. First of all, I think, Susan and Betsy, what you've done in the thoughtfulness here is extraordinary, and I want to give you respect for it. I do think there's more that could be put out in the public, perhaps not just on Title II, but also on Title I, in a way that isn't scary to folks. I mean, Gary, there's a timing question, right? We're at a delicate moment now. So if it goes out tomorrow, it might have a different impact than if if Susan and Betsy do their work and it goes out as we're moving out of the recession. But I'm very big on transparency. I think transparency leads to accountability. The FDIC has to have flexibility. So there are some ways that you could get out some basics, which say, we could do this, we could do that. We will be holding these folks accountable. We have these powers, we have these authorities. Without putting too much out there. I get that we live in a tweet world, but that 1994 book that the FDIC did on this, I mean, that's a Bible, right? And so folks who want to know about it. One final thing is, I think that there's an additional group of stakeholders that exist today that need to know more about resolution planning that didn't exist when we started on this journey. And that is the kind of fintech, non-bank lenders, money transmitters, digital assets, crypto exchanges, whatever we want to call them. I know you've listed domestic authorities, and I think there are states that are starting to think, should we have a resolution plan? And there's so much learning here that could be of benefit to those who are thinking about different kinds of resolution plans, and they would be very different if you could put a little bit out more in public.